Lively's opposition to Wayfarer's motion in limine number 16 to preclude evidence and argument of reputational harm damages. Okay. Defendants seek to preclude Lively from introducing evidence of reputational damages attributable to defendants' retaliatory conduct by recasting a damages issue as a discovery sanction. They insist that Rule 26A1A3 requires a precise computation of reputational harm damages and that Lively's claimed failure to do so warrants a wholesale preclusion under Rule 37C1. But reputational harm is a paradigmatic, can't say that, non-economic injury. Courts in this district recognise that non-economic damages are inherently difficult to quantify and are not always susceptible to the kind of arithmetic computation defendants demand. What's more, Lively's detailed disclosures as to reputational harm and her experts' specific computations of it, which defendants failed to acknowledge, satisfy even their overly exacting standard. Lively's disclosures went beyond what Rule 26 requires for non-economic damages. They identified reputational harm as a damages category tied to defendants' retaliatory conduct and disclosed the methodology and estimated figures that would be refined through expert analysis. Given the nature of the damages sought and the information disclosed, the court can reject defendants' argument on this basis alone. Even if the court agreed with defendants that Lively's Rule 26 disclosures were technically lacking, defendants cannot justify the extraordinary sanction they seek. Rule 37C1, preclusion is discretionary and a harsh remedy, reserved for cases of genuine surprise and incurable prejudice, not a means to strike a central damages theory on the eve of the trial. Oh my God, do we all remember all the sanctions she asked for? Because Jamie Heath didn't want to hand over, all the video footage of his wife giving birth. And she was like, well, you should exclude him from being able to defend himself. Like, really? I mean, and it's really, in the whole scheme of it, it's kind of irrelevant anyway. That part, because it doesn't prove anything. They're arguing over which section of the video was shown to Lively. It's a he said, she said. They can't prove it either way. And Angie Giannetti allegedly at the same time saw, not at the same moment, but in close proximity to time, saw the same alleged portion of video and said there was nothing untoward about it. Might not have been appropriate, fine, but it wasn't like sexual. And Lively is a weirdo for thinking otherwise. But yeah, no, because she filed sanctions motions against Heath and was like, and one of the requests she made was that he could not defend himself, like preclude him from giving any testimony. Also, give a jury instruction to find in my favor. It was like all kinds of weird and wonderful shit that she was trying to, place with the help of, hopes and prayers. Okay, Lively continues. Lively's disclosures and timely supplementation provided defendants with clear notice of the reputational harm damages and the basis for them, and defendants identified no discovery they were unable to pursue as a result. Defendants have known for the duration of this case that Lively alleges reputational harm from the alleged retaliatory conduct, and they have had ample opportunity to explore that theory in fact and expert discovery. They cannot now manufacture prejudice by pointing for the first time to disclosure defects that deprive them neither of notice nor the ability to prepare their defense case. Factual background: Lively provided 5 rounds of initial disclosures in this case on February 18th, June 11th, July 17th, September 30th, and October 29th, 2025. Fact discovery closed on September 30th. Expert reports were served on October 17th, 2025, and expert discovery concluded on December 12th, 2025. Lively's amended disclosures included a category for reputational harm, stating that documents that may be used to support her claims include those regarding financial, reputational, economic, emotional, or other harm or damages. Nevertheless, defendants served discovery requests and subsequently filed a motion to compel discovery from Lively focused only on economic harm. Likewise, the court's July 17, 2025 order granting and denying in part focused on Lively's disclosures as to economic damages. Lively served her second and then third amended disclosures subsequent to the court's order, at which point she provided an estimated damages figure in connection with the alleged retaliatory statements. As of October 29, 2025, Lively had made her fourth amended disclosures well in advance of the expert discovery concluding on December 12, 2025. Lively's fourth amended disclosures included the following as to Lively's reputational damages. In the amount of approximately $24,375,267, based on a conservative estimated 116,959,530 impressions of the defamatory statement subject to expert testimony. In the amount of approximately $36.5 million to $40.5 million, based on a conservative estimated 176,738,781 impressions of the terms bully, mean girl, and tone deaf attributable to the retaliatory campaign, which impressions are subject to expert testimony. Lively's fourth amended disclosures also made clear, as in prior disclosures, that these assessments are conservative and subject to amendment, that Ms. Lively has identified each damages figure as the minimum sought in each category based on presently available information, and that Ms. Lively's damages depend largely on expert discovery, and the precise method of calculating damages is subject to expert discovery where applicable. I mean, I find it wild that she's seeking $40 million because people use the terms bully, mean girl, and tone deaf a lot to describe her during the marketing of this film. Lively has never even been worth $40 million. Across a 20+ year career, at no point has she ever been worth $40 million. Yet, if you listen to her, in the last year and a half, that's how much she's lost, and that's what she's claiming in damages. That's just wild. She was only paid like $1.75 million for It Ends With Us, and aside from Another Simple Favor, that was her highest paid film. She's not she's not the A-list star she thinks she is. I don't know how they've come to that calculation. She is nowhere near worth that. Okay. Lively adequately disclosed reputational damages under Federal Rules of Civil Procedure 26A1A3. Okay. Lively's disclosure of non-economic reputational damages satisfies Rule 26 requirements. Lively seeks reputational damages for the harm incurred in connection with defendant's retaliation campaign. Under California law, reputational harm is a subcategory of non-economic damages, which in turn are permissible in connection with her claims. Lively seeks her reputational damages pursuant to this framework. Non-economic damages are inherently difficult to quantify. This court and others have acknowledged limitations of doing so, as well as the appropriateness of such subjective assessment for the jury. Where damages are subject to expert testimony, supplementation may be permitted so long as a party had already disclosed the damages category and good faith basis early and reserved the right to further address it. For example, in Cates, plaintiffs disclosed damages exceeding $242 million in their initial Rule 26 disclosures, explaining that discovery and expert analysis will be necessary for a complete determination of damages, and expressly reserved their right to revise and supplement by means of amendments or expert disclosures. The court held that disclosure was sufficient. As applicable here, Lively's disclosure for her reputational harm damages satisfies Rule 26A(1)(a)(3). She identified two categories of reputational harm damages and impressions counts. 1. The retaliatory phrases tone deaf, bully, and mean girl. I cannot believe this is the crux of her retaliation campaign claims. They called me a bully and a mean girl. Oh my goodness. Tone deaf, bully, and mean girl amounting to 176,738,781 impressions in an amount of approximately $36.5 to $40.5 million. And 2. The retaliatory statements made by defendant's agent Brian Friedman amounting to 116,959,530 impressions in an amount calculated at $24,375,267. I forgot. Do you know, I thought that the judge had already said that the statements by Friedman meant nothing at all. The defamation claim for his statements was thrown out, but also in the Rule 11 sanctions, the judge expressly said that Friedman is entitled to defend his clients. It's just so silly, this is. And to try and now say, well, actually, his statements cost me $25 million. Again, if you've ever been worth $25 million, I want to see it because I'm not aware. Lively's disclosures were then addressed in detailed computations provided by Lively's expert Dr. Humphreys. Particularly in light of Dr. Humphreys' detailed calculations, defendants cannot credibly argue that they did not receive Lively's computations as to the impressions on either the retaliatory phrases or the retaliatory statements, nor the dollar amount calculations for the retaliatory statements. Thus, even though Lively seeks reputational damages, she provided everything required under Rule 26 and more. I've got a thought I need to get off my head, right? When I read this whole, all her motions in limine about Steve Sarowitz's threats, how he was going to destroy Lively, that hit piece as well about Sarowitz, he's going to use his wealth to destroy Lively, right? And then you look at the actual phrases that she's saying destroyed her, and it's mean girl, bully, tone deaf. Like, what are we even doing here in this multi-million-dollar lawsuit that has now dragged on for over a year? Like, seriously, well, no, all right, I give it, all right? A lot of people said you're a mean girl, you're a bully, and you are tone deaf. Your marketing was absolutely tone deaf. You show her marketing to the jury, especially the alcohol, which was never part, even if she proves Justin Baldoni wanted a flowery, floral-themed marketing approach, he did not want anything to do with fashion, and he certainly wouldn't have wanted anything to do with alcohol, right? And honest to God, right, Gottlieb lost his ever-loving mind in Baldoni's deposition because he product placed a healthy mineral drink that he likes, a brand of mineral drink that he likes, into the movie, right? And he's like, well, how is it any different? Well, sir, a healthy mineral drink, and you're trying to compare that to alcohol. in the context of domestic violence. And no, I'm not buying it at all. I'm not buying it at all. There's no way that Justin Baldoni would have signed off on booze being promoted. That was all lively. And it really gets to me, like, actually, that she's seeking all these damages when she abused the marketing and promotional and basically got all this free promotion for her shitty products. She got all that marketing for them. And then when people expressed disdain or, reviewed the products and said, actually, they're not that good, they're not nice, she's calling that now, she's reframing it as retaliation, backlash, blah, blah, blah. And when people probably heard of Blake Lively for the first time through this film. I had never watched anything myself. I had never watched anything she'd been in before this film. And I only knew her as Ryan Reynolds' wife, right? And I'm not actually interested. I don't go Google searching people's wives because I have no interest in them whatsoever. But when she was the star of this film, I was like, I took an interest. And that's when I saw some of her old interviews and, some of her old missteps and how she treated co-stars and, the allure, the antebellum, the plantation wedding. That's when I found all of that. And that was very much organic. Because, and I think that's what's happened here is people have actually, become aware of Blake Lively, gone, oh my God, how is she promoting this film? What is she thinking? And then gone and Googled her from that. And then they found all her past stuff and gone, oh my God, she's always been an asshole. It's not just right now. But do you know what I mean? This is how I think all of this has happened. But instead of just accepting that and going, do you know what? I made a boo-boo, right? It all died down, right? But no, she had to rehash it with this lawsuit, with the CRD and the New York Times article. And, she keeps hanging her name to people like Ryan Reynolds, to Taylor Swift, to Gigi Hadid, to Bradley Cooper, to Matt Damon, in the hope that that's going to bolster and you think, well, these people like her, so she must be not a nice person. And that all that's done is bring them down too. It didn't work. And then she's tried to hang her hat to Jenny Slate. Well, she hasn't got a good reputation either. She's admitted to domestic violence. She has got videos of herself in her underwear with a see-through dress on, wiggling her ass, and then moans that, think I was too sexualized. People are commenting on my body, on my clothes. Well, you keep putting yourself out there. And then finally, and I do think this was like the end product then, to try and make herself look more of an innocent person, was to find her lookalike mini-me, who was fresh-faced and had no controversy really, because this was her first acting job. She had, ties to, big players in Hollywood like Rosemary Clooney, George Clooney, etc. Amongst other people. She's, Isabella Pera comes from quite a distinguished family in Hollywood. And then she tries to, she's walking around parading her like some, prize cattle, and got her in her grasp like she's, taken this poor, unsuspecting victim under her wing, thinking that that will rehabilitate her, because everyone will look at Isabella Farah, who does look very lively, and go, try and associate the innocence from her and pass it, it'll emulate and provide some kind of glow around Lively and a halo above her head. But that did not happen either. The backlash hit Farah too, for being equally an asshole, for being, nice and kind to Justin Baldoni and praising him and just saying some lovely things. Spending 5 minutes with Lively, all of a sudden, he sexually harassed her too. You can't make this shit up. Everything Lively touches turns to shit. She's like a Medusa, if you stare at her, you turn to stone. And that's the reality of what I believe Lively's reputational harm amounts to. And it's sad to say that. It's sad to say that someone is that toxic that they've had that effect. But you just look at all the people and who else has been tarnished. Colleen Hoover was a bit of a mishmash, you either loved her or hated her. And she had a lot of backlash for various missteps of her own. Not least, her own marketing of the book, which was very similar to Lively's and met with the same backlash, just not on the same scale, because Colleen Hoover is, compared to, you know, Lively and Reynolds, is relatively unknown. She's a big deal in the book industry, but in the film industry, she's not. But also, Colleen Hoover got backlash because of the way she handled the allegations of her son sexually harassing a minor, and how dismissive she was, how she called the girl a liar, etc., and just didn't deal with it. She's also received backlash because Colleen Hoover is writing about an experience that really she has never experienced, right? And I say that, as much as she's forever parroting the line, oh, well, my mum experienced this, right? When you actually watch It Ends With Us, right? If you haven't seen it, that first incident, right, the oven incident, which Hoover says is the only incident really that happened in real life to her mum that's in that film. That could easily be passed off as an accident, and to be honest, it looks like an accident. I watched the film again last night with my husband, and I said to him, "What do you think?" He's never seen it. I said, "What do you think of this?" Right now, he's a mental health nurse. He has seen all kinds of abuse. Right. He's also a professional fighter, by the way. So world champion kickboxer. So he also knows, what a real intentional hit looks like. And basically what happened is Baldoni's character was trying to take something that was burning in the oven. He tried to take it out. He forgot to put the oven gloves on and he burned his hand, right? And he basically, as you reflexively do, you throw your arm up. Oh, you let go and you fling your arm back. Go, oh my God, because you've hurt yourself. And Lively's character was at the same time, standing right there. She'd run towards him with the oven glove and she was caught. It was an accident. It was categorically was not abuse. There was no intention to hit her. And in fact, what happened next was because he dropped the oven tray with I don't know what it was, like a quiche or a pie or a lasagna or something in it. Whatever was in the oven, it was in like a glass oven dish, and he dropped it and the glass smashed, right? And then in response, almost in reflex also to being kind of caught by this hand across the face, Lively's character then pushed Baldoni's character onto the floor where he put his hand on the glass and cut his hand. Now that's important because he's a neurosurgeon and he had like a 20+ hour surgery coming up. So they both hurt each other. It was an accident both times. But yeah, that was portrayed as abuse. It wasn't. And then there was a second incident, right? That obviously we do later on in the film where he attacks her and tries to rape her. Yes, absolutely. He tried to hurt her and he bit her. That was the other thing. He bit her. Tried to bite that tattoo off. But the second incident then was where he tried to walk away, right? He was pissed off. He found that she had Atlas's number. Atlas was her ex, etc. And he tried to walk out the building. He tried to go down a flight of stairs. And she was running after him, trying to grab at him, right, whilst they were running down flights of stairs. Now, I didn't actually, in the scene, you don't see him physically go to push, literally shove her with any intent. What you see is there's a bit of a tussle, and she then kind of loses her grip and falls. Again, that is passed off as abuse. I don't agree with it. That is not what abuse looks like. But I also think, the entire film, right? If you're so scared of this guy that you're taking him to the restaurant that your ex owns whilst openly flirting and sneaking off to secretly chat with your ex in the toilets, right under his nose, then that is not a good portrayal of abuse either. And also the fact that after what I would call the only abuse incident, she was able to get up, walk out, and, get away from the situation immediately. She even went and had treatment for her injuries in the hospital where her abuser works. It was with her ex there. And for me, the whole story just tells me it's been written by someone who hasn't got a clue what abuse looks like. And then the film has been acted out and edited by a person who does not have a clue what abuse looks like, at least from a woman's perspective. It was unbelievable. And then when you read the book, there's actually a section, like an epilogue, where, Colleen Hoover talks about herself and openly admits that she never actually saw anything. Her parents were divorced before she was 3 years old, and her relationship with her dad was very, very good. So she never actually witnessed any abuse whatsoever to be able to put into words and try and portray it authentically, which just makes the fact that, Justin Baldoni onboarded a domestic violence charity, and the fact that neither Colleen Hoover nor Blake Lively sought out those resources, that advice, the experience of people who have really gone through this kind of stuff and the reality of it, it just makes it, for me, even worse. And now she's upset because people said she was tone deaf. It sticks in the throat, especially given all the harm that she's actually done to women. Okay, we're going to continue this. Sorry, that was a bit of a side note, but I feel like these are relevant factors, right? These are relevant factors, and as bad as the book was, I mean, it was a decent book, as long as you're not trying to portray, and kind of, I didn't think it was the right book to raise awareness of domestic violence, put it that way. But I was open to seeing what Justin Baldoni was going to do with it, which direction he was going to take it in. But the cut I was watching last night was Lively and Hoover's cut, according to Lively. And you very much got that feeling of that. Because I'll tell you what else irritated me so much. I did not see until last night, actually, when I watched it again, was I know a lot of people criticize Meghan Markle because when she's doing interviews or, doing documentaries or whatever, like she's on TV, she's laughing all the time. Have you actually watched this film? Like, Blake Lively laughs the entire way through it. Why? Why? I don't get it. I don't get it. Like, she laughs at her father's funeral. She laughs talking about her father dying only a few days ago. She laughs in the face of her abuser. It's like all the way through it is just this ridiculous laugh. And the way she is in the interviews as well, that stupid, like, oh no, and arms waving everywhere. And it's like, oh wow, you're just playing yourself. That's why I don't like your character. Anyway, I felt like I needed to get some of that off because I think this is important, right? If you haven't read the book and you haven't read the film, I think people need to when they're looking at this lawsuit. It's obviously not essential, right? I'm happy to sit and say, hey, do you know what? I have read the book and I've watched the film, and this is my honest opinion. And it could have been something great, but it wasn't. I do want to see, like, Lively in one of her other oppositions to motion limine wants to bring in evidence that, her friends who saw her cut preferred it. Like, that matters. Well, okay, let's all see Justin Baldoni's cut. Put it out, release it globally, and the world will give Lively her opinion on which one did better. Okay, so we continue on reputational damages. But yeah, I'm sorry, I am just pissed off that she's seeking tens of millions just for being called tone deaf and a mean girl. I think that's just the height of patheticness. Thus, even though Lively seeks reputational damages, she provided everything required under Rule 26 and more. She disclosed reputational harm as a category of damages, tied that category to defendants' retaliatory conduct in the form of retaliatory phrases and statements, disclosed the impressions-based methodology used to quantify the reach of the challenged retaliatory phrases and statements, identified the number of impressions, providing the basis for each, calculated the particular dollar damages associated with the retaliatory statements, and explained that expert analysis would clarify these figures as discovery progressed. Lively's expert disclosures, reports, and testimony of Dr. Humphreys in particular provided additional detail. Nothing more was required. Defendants cannot satisfy Rule 37C1's standard for preclusion. Even if the court were to conclude that Lively's non-economic disclosures should have been more detailed in some respect, Rule 37C1 still does not warrant the drastic sanction defendants seek. Courts in this circuit evaluate preclusion under Rule 37C 1 by considering 1. The explanation for the disclosure issue, 2. The importance of the evidence, 3. Prejudice to the opposing party, and 4. The possibility of a continuance or other cure. Okay. Defendants do not meaningfully engage with these factors, discussing only 1 and 3, and they cannot carry their burden to show any asserted non-compliance was neither substantially justified nor harmless. First, to the extent Lively's reputation damages disclosure is insufficient, it is substantially justified given that these damages are non-economic and the quantification as to the spread of harm was appropriately the subject of expert analysis. This is particularly so given that Lively disclosed the category in which she sought damages, i.e. reputational, attributed these damages to specific key themes of the retaliation campaign and statements made in relation to defendants' retaliatory lawsuit, and provided the relevant calculations, i.e. tracking the impressions of those themes and statements, later addressed by expert testimony to defendants. Second, the evidence goes to a central component of Lively's damages case, the harm she suffered to her reputation as a result of defendants' retaliatory conduct. The fact that evidence is of obvious importance for a party's claim is a factor weighing in favour of permitting the evidence, not excluding it. Third, defendants articulate no concrete prejudice suffered by Lively's disclosures, no specific discovery they were unable to pursue, no expert analysis they were prevented from conducting, and no unfair surprise at trial. Non-compliance is considered to be harmless when the party entitled to the disclosure has not been prejudiced. Demonstrating prejudice is a particularly difficult showing when it comes to non-economic damages. Defendants assert 3 types of prejudice. 1. The inability to serve written discovery requests for information relating to Lively's alleged reputational harm damages. 2. The opportunity to examine fact witnesses, including Lively, regarding reputational harm damages. And 3. The inability to computations for their own damages experts to analyze and refute. The inability to computations. Not quite sure what they're saying there. That doesn't make sense. With respect to written discovery, defendants were on notice of Lively's theory of reputational harm from the moment her lawsuit was filed, and Lively has long alleged that the retaliation campaign was based in part on defendants' perpetuation of false and misleading narratives regarding her. Yeah, but in fairness to Wayfarer, her definition of retaliation, i.e., the time frame, the people involved, etc., has expanded and changed all the way through this. Firstly, it was like these people from August. Then it was from August to December. Then it was, more people, and it started earlier. Then it was, it's more people. It started earlier. By the way, it's still ongoing to this day. A year and a half later. So no. You can't say, well, defendants have known from the start, because Lively's retaliation claims and what she defines as retaliation has evolved, and in her own words, is still ongoing. Like Friedman's statements, were made during the lawsuit, not before it. And then all of a sudden she encompassed that as well. And still does, even though the judge has been like, no. Further, defendants were well aware that Lively was pursuing reputational damages, including as of June 2025, while the fact discovery period was open, and were entitled to ask Lively questions regarding them. Defendants also had the opportunity to question fact witnesses regarding defendants' narratives surrounding Lively as bullying, tone deaf, and mean girl, as well as the other retaliatory statements during fact discovery, including to Lively. Indeed, defense counsel addressed them directly to Lively during her deposition in July 2025. And then they quote, anytime you're in a case like this where words are either spoken or in writing, spoken or in writing are at issue, it is important for the defendants to find out what words you're complaining about. And you testified earlier, and I did hear this, that you were upset that they said your character was, they called you a liar or something like that, and that you're a mean girl and you're a bully. So those are specific things we can react to. Nor are defendants able to credibly claim that their expert discovery was prejudiced on the basis of Lively's disclosures, as defendants admit. Lively's disclosures encompassing the category of reputational harm were made in advance of the submission of expert reports on October 17th, 6 weeks prior to the close of expert discovery in December. The opinions offered by Dr. Maislin and Dr. Ashley Humphreys further addressed this subject. In particular, Dr. Maislin's report discussed the proliferation of the terms tone deaf, bully, and mean girl, and their association to the alleged retaliation campaign. Further, Dr. Humphreys' report addressed the impressions stemming from both the retaliatory phrases amounting to 176 million impressions and the retaliatory statements amounting to 116 million impressions. And Dr. Humphreys additionally addressed detailed calculations as to the cost to repair the harm from the retaliatory statements. Defendants were on notice of these reports. They were able to question the experts about their opinions on this subject and were able to submit rebuttal expert opinions on these topics. Further, counsel for defendants was able to ask questions of Dr. Humphreys regarding her computations. They chose not to ask a single question regarding her conclusion that the retaliatory phrases generated 176 million impressions, and asked only a handful of basic questions regarding the cost to repair damages figure associated with the retaliatory statements, all of which suggest that defendants felt that they had all the necessary information that they now claim to be deprived of. In short, defendants were not deprived of meaningful discovery opportunities in connection with Lively's disclosures, and any prejudice claimed now is negligible at best. Fourth, defendants, having never raised the alleged deficiency prior to the instant motion, had proposed no less a measure than complete preclusion. However, to the extent the court identifies any discrete gap, it can be cured through narrower measures than the drastic exclusion requested by defendants. The court should reject defendants' attempt to exclude relevant reputational damages arising from defendants' retaliatory lawsuit. I mean, wow, they're dedicating quite a lot of time to this, obviously, because it would be disastrous to their case if Wayfarer successfully had their damages excluded. Defendants additionally seek to exclude any reputational damages associated with Dr. Humphrey's assessment of 116 million impressions and $24 million in damages calculations regarding the retaliatory statements, on the grounds that Lively's defamation claim has been dismissed, on the grounds of fair report or litigation privilege. Defendant's argument rests on the false premise that because the court dismissed count 13, the defamation, on privilege grounds, defendant must be barred from presenting any evidence or recovering any damages stemming from the retaliatory statements. That is not the law. The dismissal of a cause of action on privileged grounds does not preclude the underlying conduct from the case where it is independently probative of a different surviving claim, here retaliation, and independently supports recoverable damages flowing from retaliatory acts. Dr. Humphrey's assessment of the retaliatory statements made by defendant's agent Brian Friedman regarding their retaliatory lawsuit remains applicable. Lively need not and will not try count 13, but she's entitled to prove that defendants engaged in retaliatory conduct that includes public attorney statements alleged to be part of the retaliatory campaign, and that such conduct caused reputational injury. Accordingly, the court should deny defendants' request to exclude plaintiff's reputational harm damages evidence and the related calculated impressions on the ground that count 13 was dismissed. At most, the court may, if it deems appropriate, issue a limiting ruling that 1. Plaintiff may not present the retaliatory statement as a basis for defamation liability or defamation damages, but 2. Plaintiff may introduce the statements and Humphrey's damages quantifications as evidence of retaliatory conduct, causation, and reputational injury recoverable under Lively's retaliation claims. Okay. I'm not sure how Lyman will sit on that. I couldn't even guess it, to be honest. It literally could go either way. But yeah, so I said a lot there, so I won't continue talking on it. The next video is the opposition to Wayfarer's motion in limine number 17, which seeks to preclude evidence and argument relating to plaintiffs' allegedly lost profits and lost royalties.